Good morning. Happy Monday. I hope everybody had a wonderful Father's Day or Juneteenth or whatever you celebrated, if you celebrated anything this weekend. As far as Long Island Audits is concerned, he did state in my comments that if he gets a statement of decision or a transcript that he would send it to me. I think that'd be interesting to review to see how good the mayor's arguments were as far as standing and how apparently unconvincing Long Island Audits were. And I say that they're apparently unconvincing because the court ruled against him, so that means they weren't convincing. On Long Island Audits tickets, there's been a lot of dumb people saying dumb things in my comments. The federal case was filed on June 9th of this year. For apparently things that happened back in February of this year. Two counts, unlawful entry and filming. 2 counts. And both tickets were marked with appearance mandatory. You can't just send in a check like you could for like speeding tickets normally. But apparently, allegedly, the CVB contacted Long Island Audits and just said, if you just pay, I think he said like $250 or something like that dollars, then we'll close the case against you. So it'll be interesting to see how that works out, whether or not this turns into like a conviction. Like, if you pay a ticket, like a speeding ticket, at least in California, that's... Now you have a point on your record. I'm assuming that him paying these tickets means that he's going to have these criminal infractions on his record, which means that if he does it again, if he goes on a military base again and does the filming again, the odds of him being treated more poorly next time increase. So I hope he's learned his lesson. I mean, $250-ish is a pretty inexpensive lesson to pay. He probably made more than that from the videos, but I hope he doesn't take this the wrong way and think that it's just going to be $250 again next time, because it could be worse. So, I hope he learns from it. We'll see. As for people not learning from it, Lane Myers has filed a motion to modify the conditions of his parole. And it's a very weird motion. Lane Myers is a very weird person, and so it stands to reason that he would write a very weird motion. He cites one Arizona case in the entire thing that really doesn't help him, as far as my reading of the case is concerned. I don't know exactly what he thinks he's going to do. He cites a California case, which is odd because California law is absolutely not binding at all on Arizona. We have different statutes, different case law, different everything. So I'm not entirely sure why he cited that. And then he cited a whole bunch of federal cases, which again, don't really have any bearing on what Arizona does. Yeah, the Supreme Court cases kind of set the basic framework for how the First Amendment is supposed to be interpreted, but there's going to be a lot of Arizona case law interpreting the Supreme Court cases and applying the meaning behind the ruling in the Supreme Court case to Arizona case law. So if you're dealing in state court, you have to deal primarily with state cases. I mean, there might not be a state case on point. You might have to refer to a federal case for their understanding of a similar rule or something along those lines. But if you're ever in a position where you're litigating a state issue, like a violation of state law, in a state case like Arizona, you have to refer primarily and almost exclusively to state case law, or else you're doing something wrong. your interpretation of that Supreme Court case and its holding may not align with the state court's interpretation of that Supreme Court case and its holding. And the state court's interpretation is binding in your courtroom if it's a state case. The trial court has to abide by the state's interpretation of the Supreme Court case. They have to abide by their Supreme Court, the state Supreme Court's case law regarding that U.S. Supreme Court case ruling. Or if there is no state Supreme Court case on it, then they have to refer to the state appellate court, their understanding of that U.S. Supreme Court case. That's what's binding. There's layers in between you and that Supreme Court case. And if you're not aware of it, you probably shouldn't be writing your own briefs. But it's also weird because it's almost like he's trying to relitigate the conviction. He pled guilty to 2 counts of criminal harassment. And his argument is essentially a motion for reconsideration, as far as I read it, disguised as a motion to modify probation conditions. And it's a motion for reconsideration on sentencing, kind of, and conviction, kind of, because he's still arguing that these people are public figures, that the victim and her husband are public officials, and that being able to cover them is a First Amendment, a protected First Amendment issue. But that was already decided by him pleading guilty to harassing them by making videos about them. So it's essentially a motion for reconsideration, not just on sentencing, which is obvious, motion to modify probation conditions or parole conditions, whatever. Probation. It is probation. I think I said parole earlier, but it's probation. But he's attacking both, and it's really weird because they're not public figures. They're both employees in a specific circumstance, like where the attorney is prosecuting a case that might be a matter of public importance, and you might be maybe able to make an argument that your probation conditions need to be modified so that you can cover that particular case, because that particular case is a matter of public concern. But he's not doing that. He wants to cover the people. I don't think he's going to win on it. I don't see him winning on it. I don't see probation going for it, because by covering the people, that's how he got the civil harassment, or not he got a civil harassment. He also got a criminal harassment conviction. So covering the people is going to be an issue, and he wants to cover the people, and he hasn't made a good argument for covering the people, and covering the people was a problem in the first place. So I don't think probation is going to go along with it. I don't think the state's going to go along with it. Obviously, the victim's not going to want that to happen, and the victim, I believe, will have a say in the matter. So I don't think he's going to have any real success on that particular motion. But you can never 100% predict what a court would do. But if I had to go to Vegas and bet on it, I'm going to bet that it's not happening. There's just so many issues with the motion. And I honestly don't think it's in his best interest to have that condition removed, because he's shown a particular inability to not harass people. And I'm not trying to be judgmental on him. I'm just saying that, he does have really bad ADHD. He does apparently like to use marijuana, which can exacerbate certain psychological conditions. And giving him access, giving him the ability to do that, to make videos about these people, I think will just end up having him violate there's a permanent restraining order on him from harassing these people, and it would be new charges if he did it. So I don't think it's in his best interest to have those conditions of his probation removed, because I'm not psychic or anything like that, but I only see him violating the restraining order and potentially incurring new criminal charges. And I mean, he's at least a 2-time felon now. I mean, he was lucky he got a probation as his sentence in time served. But you get what I'm saying. Like, it could go a lot worse for him. I don't think that Arizona is particularly lenient on third strike felons. I don't think they are. They could be. You know, a lot of it, the judge does have some discretion normally, and maybe, you know, he could plead it down to misdemeanors or whatever, but it's not going to be good. So, you know, if I could ever give Lane Myers one piece of advice, it would be just don't make videos about these people anymore. And Jim Finch, Big Jim Finch, making videos about you is different than you making videos about them. I know you don't see the difference, but he's covering a criminal case. That is a matter of public concern. Not that you're necessarily a public figure, but the criminal case, is a matter of public concern. You're central to it, but you're not what makes it a matter of public concern. It's the case. Criminal trials, most legal things in court are matters of public concern. That's why the default is that the public has access. That's why in criminal cases, the defendant has a right to a public trial and newspapers have a right to cover it, or the news has a right to cover it, meaning the public has a right to be there. There's 2 constitutional provisions that make that available. Now, you know, your right to a fair trial trumps both of those. So if there is a conflict, the right to a fair trial prevails. But it's a matter of public concern. So again, if Lane Myers said, you know, the attorney husband of the victim is covering this case that is prosecuting this case, it's a matter of public concern, and I would like my probation conditions modified so that I can cover the case, he might have a shot at that. But Lane Myers can't seem to grasp the difference between covering the person, and I don't think either of those 2 people are public figures, and you can't make someone a public figure just by covering them or just by making videos about them, and now all of a sudden they're a public figure. They're not a public figure. It's never been established in court that they're public figures, and I don't think they are. At best, they were public employees at one point. And I'm using different words because they mean different things. A public employee is not ipso facto a public official or a public figure. So what Big Jim Finch is doing, covering the Lane Myers case, is different than Lane Myers covering the victim, who was at least a public employee, and her husband, who is, I believe, still currently a public employee. Neither one is elected. So, and they're not police officers. And I don't know of a case in Arizona that establishes a director of whatever, who had a prior job of director at whatever state school, is a public official, or a city attorney is a public official. I don't know of any Arizona case that does that. That's where he'd want to go if he was trying to go down this route. But again, that's just basically a motion for reconsideration, and I don't think it's proper at this point. But anyway, that's all I got for you today. Thanks for watching. Have a great day.